Hey guys, so up until the point of this video, we have talked about the differences between civil liberties and civil rights. The civil liberties being the constitutionally defined freedoms that you have that protect you from unnecessary or arbitrary government interference versus those civil rights, which are those policies of the government that prevent discrimination, right? It's supposed to provide equal protection for all citizens. And we've also talked about how the Bill of Rights, up until the really 1920s, was simply protecting people from the federal government. And then with this doctrine of selective incorporation, moved the Bill of Rights to apply to states. So what I'm going to have us start off with in this video is taking a look at really civil liberties, and we're going to start with the First Amendment, specifically the free speech and free press clauses of that First Amendment. So if you remember, our framework for this unit is really to take a look at and explain how the court has interpreted our civil liberties over time, and in particular here, the First Amendment's rights to free speech and press. And they've changed their interpretation over time to balance individual liberty and the promotion of public safety and order. So today, I'm going to give us examples of court cases and situations where the courts have interpreted the First Amendment rights a little bit differently depending on the circumstances. And then also, moving up a little bit, our other learning target for today is to define the types of speech and then the limits of speech. So the First Amendment itself really has a lot of clauses. There are 5 in total, but a lot of those are centered around the freedom of expression. And when I'm talking about freedom of expression, I'm talking about expressing your opinions, talking about your emotions, opinions about the government. And that can be in spoken word or written word. And free speech has always been considered to be fundamental to our democracy, right? If you remember from American history, you were thrown in jail for speaking out against the king. So our founding fathers really wanted to make sure that we had the ability to express our opinions without fear of retribution or punishment within reason. And we'll talk about what that is, reason, what that within reason means as well. Now, freedom of expression in terms of speech and press ultimately over time has been designed to prevent government censorship, right? As I said, we were worried about the government coming after us if they did not like what we had to say, if they did not like our opinions. But this has been defined by the courts over the last 230 some odd years, not by the Constitution. The Constitution simply states that Congress can make no law infringing on a person's freedom of speech. But the question has become, under what circumstances is your right to free speech protected? And in what circumstances is free speech not, right? Free speech, as we've talked about, is not absolute. When one person's right to free expression violates another's right to peace, safety, decency, it starts to infringe on the rights of others or go against public interest, that's when your free speech can be restricted by the government. Okay. Now, it's not absolute, but that doesn't mean that the government doesn't have restrictions on it as well. So one of the restrictions that the government has on freedom of speech is that in order to curb our freedom of expression, whether that is spoken or written word, the government has to show what is called compelling governmental interest. And this means it should have a purpose important enough to justify the infringement of personal liberties. The government actually has to provide evidence to prove that this is something so monumental and so important that they have to curb someone's First Amendment rights to free expression. And that is not easy to do. There is a very, very high bar for this compelling governmental interest, as we'll see in the cases that we talk about today. When it comes to written word, the government also has no prerogative of what is called prior restraint. And what that means is the government cannot suppress a thought or a written word from entering the marketplace of ideas just because most people would see the idea as maybe repugnant or offensive, or they don't agree with it. Basically, it prevents censorship when you think about it that way. They do not have, or there is a very high standard when it comes to the government stopping spoken or printed expression in advance. And we'll take a look at a required court case of prior restraint as we go through this this lesson. Now, there are exceptions, as always, that allow state and federal governments to limit forms of speech. And that's what we're going to focus on for a large portion of the rest of this video. So there are a couple limits to free speech. The first is dangerous speech. And there are a couple of rules when it comes to speech that would qualify it as dangerous. So, for example, speech cannot threaten national security. So this brings us to a required court case, Schenck v. United States from 1919. And this is a case that you need to know for your AP test. This is ultimately saying that if the courts can tie your speech to a specific threat to the country or to the government, they can take away your free speech. And this case ultimately established what has been come to be determined as the clear and present danger test, right? If it is shown to incite violence against the country, a government official, you do not have the right to say it. Okay. Another thing here with this clear and present danger test, it makes the distinction between the theoretical and the literal. So you do have the right to talk about the theoretical overthrow of the government. Absolutely. But your words cannot incite people to take an illegal action, right? So what we will see here is a difference between talking about the abstract, right? Like, man, I really don't like the government right now, versus inciting people to take action that would cause an overthrow of government, like encouraging people to go out and assassinate a leader, right? That's an extreme example, but that's the difference between the theoretical or the abstract and the literal here, okay? Dangerous speech also includes personal danger. So you cannot use fighting words. You cannot make threats against the safety of others or loved ones of others, for example. One of the biggest examples that comes with dangerous speech, and you hear this from when you're really little, is you can't go into a crowded room and yell fire, right? You're inducing panic. That would be that clear and present danger test. You can't say things like, if you do this, I know where you live, right? Those are threatening words, fighting words that would lead to your freedom of expression being restricted. Now, dangerous speech is ultimately something that's very flexible in our courts. Over time, the courts have restricted what people can say more than others. And really dangerous speech is more tightly enforced during times of war. And they really want to protect the country as a whole in wartime. So you will see your freedom of expression a little bit restricted when it comes to periods of war. The second limit to free speech, or type of speech, I should say, is hate speech. Now, hate speech, I want you guys to think about, this is speech that is done by groups of people like the KKK, the Westboro Baptist Church, that say pretty repugnant, horrible things about specific groups of people, whether that's based on race, gender, sexuality, things like that. If you're not familiar with Westboro Baptist Church, that's that group of people that protest funerals of soldiers that have died in conflicts, viewing their death as basically God's retribution for our sins in our country. They've actually protested at Oak Hills High School, and a lot of people consider them to be a hate group. Now, hate speech is almost always protected by the courts. And I know that that sounds very weird, but you have to think about what would happen if we didn't allow hate speech to be protected. Democracy, according to Thomas Jefferson, was this marketplace of ideas, right? We as consumers of speech have to decide what is acceptable and what is unacceptable. So imagine if the government was the one doing that deciding of what's acceptable and what's unacceptable. They were judging that standard. It would get very dangerously close to that censorship that we were always afraid of at the founding of our country. So, because we have a marketplace of ideas in our democracy, as a marketplace would, your speech is put out into the market and people can quote unquote buy what speech they want, if it's good, or they can decide what's good and appropriate. So basically, it comes down to this idea. And this is from Voltaire, a little bit before the founding of our country. But I despise what you have to say, but I will defend to the death your right to say it, right? If we start restricting hate speech, right, what is hate speech for one person is not hate speech for others. So it's a very, very gray line in terms of what is allowed and what is not. So that is why hate speech is almost always protected. Now, there are limits. Hate speech can be limited by time, place, and manner. So governments can regulate where, like rallies, for example, happen. Now, it's very important that these regulations do not limit what is being said, but regulates the conduct of those saying it. So, for example, when Westboro Baptist Church came to Oak Hills High School, they could not be on school property. They had a time frame that they had to show up, and they had to have a permit. So you will see that those restrictions often are in place to curb the conduct or regulate the conduct of those participating in hate speech, but not necessarily restricting what is being said. Okay, another limit to free speech or type of speech is symbolic speech, and this is nonverbal speech. But ultimately, your nonverbal actions communicate a message, often politically. So examples of this would be kind of what you see here on your screen. Wearing armbands in protest of the Vietnam War, like they did with Tinker versus Des Moines, which is one of your required cases, and we'll talk about here in a second. Burning the American flag is an example of symbolic speech that is protected by the First Amendment. This caused a huge uproar a couple of years ago, led by Colin Kaepernick, where they were kneeling during the national anthem for NFL games, and that kind of reverberated throughout the country. That is an example of symbolic speech. Now, this is generally protected even if it's anti-American, and it even goes back to that idea of the marketplace of ideas that we just talked about before. Now, the only restriction is that it can't create a danger to others. So that clear and present danger standard is still there when it comes to symbolic speech. And there have been times where symbolic speech has not been protected because of times of war, for example. Now, the biggest case to know that really incorporates symbolic speech would be Tinker versus Des Moines. And these students here, the Tinkers, wore armbands to protest the Vietnam War. They were suspended, and they argued that they were simply using symbolic speech. They did not, create a riot at the school. They were simply wearing something to protest something politically. And the court agreed with them that they were allowed to use symbolic speech in schools. And actually, this case of Tinker versus Des Moines, symbolizing the court's agreement of symbolic speech being protected, actually leads us to another type of speech that is consistently being interpreted by the court system, which is free speech and schools. So Tinker versus Des Moines actually showed that students do not check all of their rights at the door of the school. Students retain some of these rights. However, they are limited. And the reason for this is schools have the function of learning. If your actions prevent the ultimate purpose of this, the school can restrict free speech of students. So if your actions or words incite panic or chaos or disrupt the learning process in any way, then your free speech can be limited. So, for example, let's say that words or a protest would create a food fight in the lunchroom, right? That would be an instance where you could get in trouble for your free speech, quote unquote, because you created something that disrupted the learning process. Something else is that school events are considered the same as school. So if you go on a field trip, all school rules apply to the field trip. So there was an example of a school field trip where a student rolled out this sign right here, bong hits for Jesus. That is not protected under the First Amendment for students, right? That is something you could not say in school, you could not wear at school because you are disrupting the learning process, it's promoting drug use, etc., etc. Now, some other, excuse me, things that are limited when it comes to school would be like privacy. Excuse me, guys. So you see signs like this throughout the building. This is just another example of how your rights, you do keep some, but not all. So your right to privacy as a student is a little bit restricted because your lockers and storage areas are subject to search without warning. If there is reasonable or probable cause to believe you have a substance, for example. Another type of speech to be discussed is obscene speech. And in general, this is not protected by free speech and the First Amendment. Part of that is we don't have a national standard that defines what obscene speech is, because we all have different standards of obscenity, excuse me. So, right, like as a teacher, I don't want to hear you guys saying the F word in class, but to you guys, that might not be obscene. And this is a really important quote that I think really sets the tone for this debate of obscenity and obscene speech. I may not be able to define it, but I know it when I see it, right? So you know what is obscene when you see it, but it's really hard to pinpoint an exact nationalized definition of what obscene speech is. And there was actually a case that established a test, Miller versus California. And if anything matches or fits this test, it is deemed to be obscene speech. So, for example, is it sexually explicit in nature, i.e. pornography? Does it lack literacy, political, scientific, artistic value, right? There are some circumstances where a nude portrait would have artistic value, but in the public sphere, pornography is not considered to be of artistic value, right? Does it have any other purpose besides just being explicit in nature, right? So that is a difference there as well. And something else that this test established is that local areas make their own decisions on obscenity. So what is obscene? And I have a good example for you guys here. Next time you go to the supermarket, whenever we're allowed out of the house again and going to Kroger or Target, take a look and try to find Cosmopolitan magazine. If you've never noticed before, Cosmopolitan usually has a gray plastic barrier that is preventing you from seeing all of the news stories. And in our area, in our county, that is because of obscenity laws. If you've never read Cosmopolitan, it's not pornography, but it does contain some sexually explicit things in nature for the reader. So the city of Cincinnati and in this county have decided that that is obscene enough to kind of censor in a public supermarket. Another type of speech to discuss is commercial speech, and this is communication in the form of advertising, whether that's on TV, the radio, music, etc., etc. And generally, this is the most restricted or regulated form of speech, and this is regulated by the FCC. And that is that regulatory agency that's in charge of making sure broadcast stations follow those rules that are set forward by the government. And the reason for this is that ultimately this is advertising. You're trying to make money. The government is going to use that Commerce Clause as justification for this regulation. Now, broadcast stations do have these strict rules. Cable and satellite stations blur the lines a little bit more. And then when it comes to music, music has even more freedom, but it must be labeled as explicit content or explicit material. And then just, relevant, but also a little bit funny. This is why Eminem always raps about the FCC won't let me be or let me be me, right? Because he felt restricted by this regulatory agency in terms of what kind of content he could provide. False speech is another type of speech that we see limited, and false speech is speech that is not true and is meant to defame someone or hurt their reputation. And there are two types of false speech. Slander is false speech in spoken form, and libel is false speech in written form. So ultimately, what this means is you cannot knowingly speak something that is false about another person and be protected by it. Now, as you can see, speech and press kind of go hand in hand here, right? These are both ways of expression, but are ultimately being restricted by the government for public order and safety. Now, there are different standards for a public versus a private individual. Some people, due to their lives, are in the public limelight. So think of like a celebrity, right? Their lives are out there more so than you and I. So they are at a higher risk of facing slander and libel for that reason. Now, in order to have your false speech protected, you must prove in the courts that your reputation was damaged based on that slander or libel. And this is not easy to do, to be able to prove that your reputation has been damaged. You have to provide physical evidence. So as a result, there's a rather high standard of defamation. And usually false speech like this is protected under the First Amendment simply because it's really hard to prove, right? So for example, the Enquirer is kind of, or the National Enquirer is kind of notorious for producing some libel. So this edition was Dr. Phil, Raging Monster, right? Accusing him of sexual assault, being a vicious bully. This would be an example of potential libel, where Dr. Phil, if he could prove that his reputation was damaged based on this, he could actually win a case, and the National Enquirer would not be protected. However, like I said, that's a rather high standard. It probably would not happen, and the National Enquirer would be protected under the First Amendment. Now, going on a little bit into free press, a little bit more than free speech. As I mentioned before, free speech and free press go hand in hand. There are many similarities to this, right? We talked about how slander and libel are the same thing. It just depends on if it's spoken or written down. And in terms of censorship, there's no prerogative of that prior restraint, restricting written word or spoken word before it is actually put out into that marketplace of ideas. And this is really reiterated by a key court case that we need to know, which is New York Times v. the United States from 1971. So background of this case, an analyst for the Pentagon released the Pentagon Papers to the New York Times. And these Pentagon Papers told the backstory of our involvement in Vietnam. Ultimately, this did not show the United States government in a very positive light. And Nixon, the president at the time, argued that this posed national security risks and tried to prevent the publication from ever happening in the first place. So the question at hand of this case was, can the executive branch block the printing of reporter-obtained classified government information in an effort to protect national secrets without violating the First Amendment's Free Press Clause? And the ruling, the outcome, was that the court ruled that the cry of national security does not justify censorship in advance. And this is what upheld the fact that the government has no power of prior restraint of publications. So essentially, the government cannot just claim it's a national security risk and then justify censoring something in advance. Remember, it has to have that compelling interest that we talked about at the very beginning of the video. So my question for us for free press is, why do we think preventing prior restraint is so important for us and our democracy? So moving on to the rest of the activity, make sure you pause, go back, get any notes that you missed, write down any questions, but you have a couple of case studies that you are going to take a look at. I want you to pick 3 of the cases that you see and tell me what type of speech is being addressed and your personal reaction to the case, whether you think the Supreme Court would agree that it is freedom of speech or it is not protected under the First Amendment. So if you guys have any questions, I will talk to you guys soon. Make sure to reach out during office hours through email or Google Meet, and I will talk to you guys soon. Bye.